Assalamualaikum warahmatullahi wabarakatuh to Dr. Fahmi and my classmates. My group will be presenting about the workplace responsibilities and rights. So, I am Muhammad Azrin bin Muhammad Yamin. So, the first thing we have to know about the human resource, which is HR. It is a department or a section in a company that is in charge with finding, screening, recruiting, and training job applicants, and also administering employee benefits programs, including social securities, health insurance, educational help, and employee discount program. So, HR professionals must help create a workplace with environment that honors fairness and also protecting the individual privacy threats to all workers with dignity and respect. The workers have rights which are not fully written down in a contract or an agreement. So the employee and employers should have a seminar or induction so that they both have a knowledge about their rights or any possible things that can lead to termination. So what is the right involved in workplace? So actually, in Oxford Dictionary, rights is defined as a moral or legal claim to have or to behave. For example, does an employee have the right to privacy of communication in personal matters when using company's computer or during working time? No, right? So, also, does employee have rights to use personal computer for working purposes? Or company has a right this personal computer things, the company has a right to command such thing because there are many reasons for this, such as to ensure the employee securities and the safety. Since their employers are having the employee to be working with them, so they need to make sure things are working properly. So second thing is about equal employment opportunity, or we can call it EEO. So EEO is a freedom from discrimination on the basis of protected classes such as race, color of skin, sex, national origin, religion, age, disability, or genetic information. It is a federal and state fair employment laws which guarantee EEO rights, which are enforced by Equal Employment Opportunity Commission (EEOC) and its state counterparts. Affirmative Action Plans (AAPS) is an employer's standard proactively recruiting, hiring, and promoting women and minorities or disabled person or any veterans to make sure making sure to amend their historical wrongs. This is also a moral social obligation to eliminate present and past discrimination. So according to Employment Act 1995, which was latest amendment was on 1st April of 2012, the Act of state the right of both employer and employee, the obligation or responsibilities they are obligated to fulfill and to have the legal protection. However, This act is only covers the workers who are wages under RM 2000 monthly, and all workers in and all manual workers, such as they are using their working without using any equipment. They are using their raw physical energy, which usually involving their physical activities. So employment contract is a contract which was made when the employee passed the interview made by the employer. So they are recruited, and then the employment contract is made. So in that agreement, or we can say contract, it is the above between both parties, which sets out the right, responsibilities, and duties. It is a written contract and usually stated in the offer letter from the employer as it is required by the law. If the employees begin working, it is appear that the employee accepted the job of the employer's term, even if they are unaware of them. So it is important for the employee to read thoroughly the employment contract. So the employment agreement should address all particulars and the relationship, including base pay, incentive compensation basis, and supplementary benefits, or the previously requisite. So it is important to know the key functions in performance criteria, terms and conditions for termination employment. Employment at will states that employers have the right to hire or to fire whoever they chose, and employees can quit at any time with or without notice. But this is usually different and varies among the companies. So important to include non-compete agreements, which prohibit individuals who leave an organization from working with the employer in the same line of business for a specific period of time. So non-compete agreement is a clause to prevent ex-employees, or we can say the former employees, from competing against their former employers by restraining them from engaging in a particular trade or business which may be demarcated by a geographical area and or limited for a period of time. So a legal agreement in a contract, non-compete agreement is also a legal agreement in a contract, which disallowing the employee from revealing proprietary information, or we can say a secret, to the company to any other parties after the employment period is over. So it is important for the market, it is important to the company to make this agreement to keep in their place, to make sure they have a place in the market, of course. So parties that should be involved in this non-compete agreement is the employees, contractors, and the consultant. Next is the non-piracy. It is also a contract may also included in a non-piracy agreement which bar the former employers from soliciting the business from former customers and clients for a period of time. So the business will be affected if the agents who have ties with those customers quits. It is different between owning a business and renting one. and it's not something wise insurance agency want to handle alone. So they suggested to be working to make the agreement with any other parties to make sure the bond is being kept handfully. So non-solicitation of current employees can be incorporated into an employment agreement where these limitations are created to protect the company from former employees attempting to recruit former core workers, clients, essentially poaching talent of business. So according to a 1996 law, theft or trade secrets are federal crime punishable by a fine of law of up to $5 million and 15 years in jail. So the employer rights in this area include the following: the right to keep trade secrets confidential, the right to have employees bring business opportunities to the employee first before pursuing them elsewhere, common law copyright for workers, and other documents prepared by employees for the employers. So non-soliciting soliciting is the contacting customers to persuade the customers to do the business with a new different operating firm. So non-soliciting agreement is for many firms. They serve a useful role in many organizations. They devote time, money, resource, whatever they have, to make sure the growth in their client base and customer list, as well as significant assets to keep the customer list discreet. This is important to make sure to protect their assets or the customer list. So the next one is intellectual property. An area often covered in employment contract is protection of intellectual property and trade secrets. Employers have rights in this area, including these three: keep trade secrets confidential, first refusal, common law copyright. So a wrongful discharge is also refers to termination of an individual's employment for reasons that are illegal or improper. For example, the illegal reasons for termination is sexual harassment, violation of all written employment agreements, and many more. So it is said that if a person is fired from a job and they believe it is the employee they believe it is a wrongful decision, especially if was done without cause. However, the legal definition of wrongful termination is fairly specified. It's also against the law to dismiss an employee for filing a legal complaint against the company or for reporting the firm's misconduct as a whistleblower. So whistleblower, my friend Arif will be presenting or will be discussing more later about the whistleblower. So the next is constructive discharge. Constructive discharge is the process of deliberately making conditions intolerable to make an employee quit. So an employee is constructively discharged when they resign because they can no longer stay on the job due to a hostile work environment. Hostile work environment, according to a research, one out of 5 workers has experienced workplace abuse or sexual harassment or bullying, verbal abuse, or unwelcome sexual attention. So public policy exception is the any employees is fired for a reason that violates pharmacy policy, and the employee have the right to sue the employer to sue the employee to sue the employer. So an employee gets fired for exercising their legal rights, such as right to vote. Employees who refuse to do an unlawful conduct, such as fabricating reports or submitting a false corporate tax paperwork, may be fired. The implied contract exception is the employee cannot be fired as long as they perform their job, and a non-service promises of continued employment and lack of criticism of job performance imply continuing employment. So due process. Due process is a fair treatment through the normal judicial system, which is especially a citizen entitlement to notice of a judge and a hearing before a impartial judge. A series of legal process conducted in accordance with established norms and principles in a system of jurisprudence for enforcement protection of private rights. The organizational justice is a fairness of decision made by employer advocate in an organization. So element of justice. There are 3 elements in justice, which is procedural, distributive, and interpersonal. So procedural focus on whether the procedure that leads to an action were appropriate and clearly understand, and whether they provide an opportunity for employee, and it is a perceived fairness of a process used to make decisions about the employee. So distributive is the perceived fairness in the distribution of outcomes per disciplinary action based on favoritism when some are punished and others are not. This is clearly a wrongful decision. So interpersonal, which is the extent to which a person affected by an employment decision feels treated with dignity and respect, is an adequate explanation provided to explain the decision, or is it the employee treated consistently? So fairness is the employee who feel that they are not treated fairly, may respond in a number of ways, sometimes even counterproductively. So procedures of making companies may improve perceptions of justice by providing procedures to deal with employees' complaints. In union-free firms, the complaint procedures differ from those for unionized employees who typically have a formal grievance procedure specified in their union contract. So due process back then is the due process, and union-free firms are more varied and may address of a broader range of issues. So another terms in policy is open door policy. So many employers use an open door policy, which allowing workers who have a complaint to talk directly to someone in management. However, if this may be mishandled, so union-free firms have it more beneficial to have more formal complete as it is written and more systematic due process than the open door policy. So different company may have different way to solve their complaints from the workers. So trust is needed for employees to trust these methods. Companies should have communicate decision clearly and give employees an opportunity to provide input, for example, using arbitration process. Arbitration is a process that uses a neutral third party to make a binding decision, thereby eliminating the need to involve the court. So the next presenter is Muhammad Arif. The next presenter is Arif. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Arif Hanafi bin Majki. I will now continue for the second part of the presentation for workplace rights and responsibilities. Okay, for the first slide is the compulsory arbitration. Common feature in union contracts, some firms use compulsory arbitration, which requires employees to sign a pre-employment agreement stating that all disputes will be submitted to arbitration. So these agreements require employees to waive their rights to pursue legal action until the completion of the arbitration process. A legal check of compulsory arbitration as a part of the Alternative Dispute Resolution ADR should be done before adopting this practice. So next is the peer review. So some organizations allow their employees to appeal disciplinary actions to an internal committee of employees. This panel reviews the action and makes recommendations or decisions. Peer review panels use fellow employees and perhaps a few managers to resolve employment disputes. So next is the ombudsman. Some organizations ensure process fairness through ombudsmen. Ombudsmen is the individuals outside the normal chain of command who act as an independent problem solver for both manager and employees at many large or medium-sized firms. The ombudsman also have effectively addressed complaints about unfair treatment, employee-supervisor conflicts, and other workplace behavior issues. Ombudsmen address employee complaints and operate at a high degree of confidentiality. They can also improve employee perceptions of procedural justice. So for mediators, ombudsmen as well as other individuals in groups who oversee disputes will sometimes use mediation as a tool for developing appropriate and fair outcomes for all parties involved. So mediators may use either a facilitative or evaluative approach to dispute resolution. Facilitative techniques foster communication among the parties to help uncover options for settlings. So then for ADR method have variety of ADR available to employers to resolve disputes in the employment relationship. So next is the right to privacy. The right to privacy is defined in legal terms as individuals' freedom from unauthorized and unreasonable intrusion into personal affairs. Then for the Privacy Act of 1974, this act was an act to protect individual privacy rights in the United States. It includes provisions affecting HR, human resource record keeping systems. This law applies only to federal agencies and organizations supplying service to the federal government. However, similar laws in some states with somewhat broader scopes have also been passed for the most part state rather than federal law. Federal law regulates private employers on this issue. Record keeping and retention practice have been affected by a provision of the Americans with Disabilities Act known as ADA, requiring that all medical related information be maintained separately from all other confidential files. So next is the HIPAA, the Health Insurance Portability and Accountability Act, known as HIPAA, also includes regulations designed to protect the privacy of employee medical records. Both paper and electronic files must be safeguarded. As a result of all the legal restrictions, many employers have established several separate files for each employee. So it is important to establish access restriction and security procedures for employee records to protect the privacy of employees and to protect the employers from potential liability for improper disclosure of personal information. Individual social security number, personal address, and other contact information should be protected. So then the Data Protection Act requires employers to keep personal records up to date and keep only the details that are needed. So for the guidelines, the following guidelines offered regarding employer access and the storage of employee records. First of all, restrict access to record a limited number of individuals. Next, use confidential password for accessing employee record about various HR database. And then, set up separate files and restricted database for particularly sensitive employee information. So next is to purge employee records of outdated data, and lastly, release employee information only with employee consent. Okay, next is for the personal files. Personal files and record are usually maintained for 3 years. However, different types of record should be maintained for shorter or longer periods of time based on various legal and regulatory standards. So another concern is how electronic records are maintained and secured, especially given advance in software, email, and mobile technology. Organizations should establish an electronic records policy to ensure legal compliance and avoid violating individuals' personal rights. So for the data privacy is becoming increasingly important with the growth of mobile technologies and the use of applications or apps that offer various functionality. Many applications collect information about users. So it is vital to ensure that an organization's policies accurately and completely identify all data being collected so that users are aware of how their personal information is being handled. Okay, then for the freedom of speech, actually there are 3 situations in which employees' freedom of speech might be restricted, including expressing controversial views. Second one is the whistleblowing, and the last one is using the internet and other communication-based technology. So, the question of free of speech can arise over the right of employees to advocate controversial viewpoints at work. So, can an employee be disciplined in situation like this? The answer for this question is likely yes, if the disciplinary action can be justified by job-related reasons and the company follows due process procedures. Okay, however, simply because an employer might not be able to punish employees who make an appropriate statement that embrace the organization, should the employee do so? Perhaps an employer should not, because employees may view this as heavy-handed and overreaction. So there are 3 best ways to handle these concerns. The first one is to attempt informal resolution first, and then the second one is clearly outline the boundaries and standards for appropriate behavior in a formalized policy that address workplace expectation. And then the last one have signed have a signed non-disclosure privacy agreement. So then whistleblower. Whistleblower, individuals who report real or perceived wrongs committed by their co-workers or employer. Several laws such as Sarbanes-Oxley Act and the Dodd-Frank Act protect corporate whistleblower. For instance, the Sarbanes-Oxley Act is intended to remedy companies' ethical breaches by requiring organizations to properly report financial results, encouraging ethical business practice, and providing protection to whistleblowers. Meanwhile, for the Dodd-Frank Act, protect whistleblower and provide financial incentive to individuals who report wrongdoing. In addition to paying fines, a company that has found guilty of retaliation is required to reinstate the individual back to his or her job. Next is to provide back pay or double back pay to make up for loss of compensation. And then the last one, to cover for the retaliation, cover any costs associated with legal counsel. Employers needs to address two key questions regarding whistleblowing. The first one is, when do employees have the right to speak out with protection from retribution? And the second one, when do employees violate the confidentiality of their jobs by speaking out? Even though the answer may be difficult to determine, retaliation against whistleblowers is clearly not appropriate or legal. For employees report, the culture of the organization often affects the degree to which employees report inappropriate or illegal actions internally or resort to using outside context. Consequently, HR professionals should be actively involved in helping the organization develop an ethical culture by creating fair and ethical policies. Employees of private sector employers can be monitored, observed, and searched at work by representative of the employer. So, then for court decision, several court decisions have reaffirmed the principle that both private and public sector employers may search desks, files, lockers, and computer files without search warrants if they believe that work rules have been violated. Numerous employers have installed a video surveillance system in their workplace. Some employers use the system to ensure employee security, such as in parking lots, garage, and dimly lit exterior areas. Other employers have installed them on retail sales floors, in production areas and parts, and inventory rooms to reduce theft and shrinkage. For the policy, it is very important that employers using such method to develop a video surveillance policy, informing the employees about the policy, conduct the surveillance only for legitimate business purpose, and then strictly limit those who view the surveillance result. Employee morale should be considered when developing policies, because employees may see monitoring systems as a sign that they are not to be trusted, which can lower their commitment and positive impressions of the organization. Employee activity may be monitored to measure performance, quality, and customer service check for theft, and enforce company policies and rules. The common concerns in a monitored workplace usually center not on whether monitoring should be used, but on how it should be conducted, how the information should be used, and how feedback should be communicated to employees. And then for business operation management, organization should strive to collect information that is needed to manage business operations, but not to track every detail just because they can. A workplace investigation is not an effort to prove or disprove allegation or to determine whether allegations are true. A workplace investigation is designed to find facts and determine what happened or what is happening in a situation. An investigator for the organization has the responsibility to look beyond the simple incident or accusation to examine the situation. Next, for the due process, the US Constitution protects public sector employees in the areas of due process search and seizure and privacy at work, but private sector employees are not protected. The problem is whether it occurs on or off the job. Employees' unethical or illegal behavior can be a serious problem for the organization itself. A workplace investigation can be conducted by internal or external personnel. The following is the best practice should be used when conducting a workplace investigation. Okay, this is the plan for conducting the workplace investigation. The first one is to develop a good working plan that outlines how the organization should respond to crises before they occur. Confidentiality should be a high priority throughout the investigation, and all important incidents should be properly documented. The next step is to specify whether human resources or another party like attorney or an accountant will conduct the actual investigation of workplace incident. If possible, select an objective and impartial investigator who does not have any professional connection to the individuals being investigated. So, for the time, investigate problems quickly before the evidence can be tampered with or destroyed, and begin interviewing key witnesses. You need to investigate wrongdoing within several days after being made aware of the incident, and try to finish the investigation within 2 weeks. So, for credibility, use the stories and information collected to conclude the investigation and recommend any remedial steps that should be taken. Present the results of investigation to key decision maker and make appropriate recommendation. And then the next is investigation serve as visible evidence that the organization takes employee concerns, policy and procedure seriously. Moreover, investigation show that an organization will diligently research all evidence related to a claim to determine what has happened. This will build a confidence of fairness among those who are aware of the investigation and beyond. An investigator who remains impartial, keeps an open mind, and respects the impact of the work has a profound impact on the fairness in the organization. For the policies, policies act as the general guideline that help focus organizational actions. Policies are general in nature, whereas procedures and rules are specific to various situations. The important role of all three requires that they be reviewed regularly. So for procedures provide a customary methods of handling activity and are more specific than policies. Last but not least, for the rules are specific guidelines that regulate and restrict individuals' behavior. They are like procedures in that they guide action and typically allow no discretion in their application. Rules reflect a management decision that action can be taken or not taken in each situation, and they provide more specific behavioral guidelines than policies do. So that's all from me. Thank you.
Hi everyone, it's me Alia, and I will be emphasizing more on the work responsibilities and the after effects when one's neglected his or her workplace responsibility. I believe both my good friends Azrin and Arif had done an exponential job well done in explaining the rights, responsibilities, and other concepts that are interrelated to them. Nevertheless, please bear a few more minutes with me as I walk through with you guys on this particular topic for our part 3. First and foremost, let us get back into the definition of work responsibilities. Work responsibilities is when an employee completes all of their job duties stated within the job description and adheres to the company policy and procedures professionally and to the best of their ability. The simplest analogy I could suggest would be assignments. By doing the assignment with the best effort we can according to the question requirements, we are actually fulfilling part of our responsibility as a student. The same concept applies when we take a step into a real-life working environment. So, why does work responsibility is extremely important? Well, responsibility is important in the workplace because it shows your professionalism, can advance your career, helps build professional bonds with co-workers, and shows company leadership that you are a valuable employee. Supervisors value employees who exhibit responsibility because they know they can trust you to complete tasks on time and submit the high-caliber work. Responsible employees are professionals with a consistent work ethic to take actions daily towards their professional goals. Now, it came to the big question of how. How shall we achieve more work responsibility at our workplace? To answer that, firstly, when working, to show you are a responsible employee, take the first step by ensuring you are fully aware of your job responsibilities. Next is integrity. Integrity is a skill and trait that takes time to develop. Employees with integrity follow a strong moral code and can be trusted to make decisions that are ethical and benefit the company and those around them. Thirdly, resilience. In other words, the will to continue when faced with obstacles and the stamina to continue after you have failed, which could lead to a successful employees and a dynamic and growing company culture. Nevertheless, do accept the consequences of your actions to take accountability. And when you have to make a decision at work, do so with confidence. Being decisive means making informed decisions and having the certainty to see them through. These are the 5 ways in which work responsibility can be achieved more. Have you ever seen a handbook or a manual book? I bet most of us had. Well, in every company or workplace, there must be an employee handbook. This handbook provides guidance and information related to the organization's history, mission, values, policies, procedures, and benefits in a written format. It is also viewed as a means of protecting the employer against discrimination or unfair treatment claims. It is an easily accessible guide to the company's policies and practices, as well as an overview of the expectations of management. Basically, the characteristic of a common handbook will be it must be written in a common language so that it is readable and also usable. Then, all controversial phrases are usually eliminated in order to avoid misinterpretation by either the employee, employers, or general law officers. In addition to that, Disclaimers are written clearly instead of using small fonts at the bottom corner of the page. This is to ensure that employees are completely aware of that section. The handbook is also updated from time to time whenever necessary. Let's say there is a new issue to be found or any changes are amended on the existing process. Last but not least, with the technological era we are in now, most handbooks are now in the form of an e-book so that they can be accessed anywhere and everywhere for easy references purposes. Moving on, I will now be explaining about upward communication. Upward communication is the process by which lower-level company employees can directly communicate with upper management. This enables management or managers to learn about employees' ideas, concerns, and information needs. This type of communication are usually in the form of employee satisfaction surveys, suggestion programs, performance reports, and also company meetings. Hence, it is our responsibility as an employee to be attending, filling in, and fulfilling all the surveys, programs, and meetings held, as it is beneficial for us too at the end of the day. Oh, let's sit back and take a look at a short animation video prepared explaining more regarding upward communication that you should know. Now that we have watched the clip just now, I really hope everyone could really take note that it is important for us to take part in this kind of effective communication in the workplace, as it affects us personally and the organization as a whole. Taking into consideration that not all communication either upward or downward is working effectively in a certain workplace, we must prepare ourselves with the existence of problematic employees or management system. Problems. Whenever we go or wherever we go, there must be problems recurring. It's the same when we are in a workplace. The common workplace problems are basically disciplinary issues caused by problem employees, such as breach of company's confidentiality, in other words, misconduct behavior, quality deficiencies, safety violations, and also insubordinations. Therefore, the highlighted question here is, what is management rules when these problems occur? The first thing is to identify violations and other behavior problems that the said employee had done. Next is then taking steps to correct them. However, if it became much worse, the Human Resource Department HR will be assisting in terms of disciplinary action. Hence, it is vital for managers and supervisors to be trained at the right time when discipline shall be used to avoid mistakes in disciplining. I had also laid down a video on how we can spot a toxic colleague or problematic office mate. Please enjoy.
How to spot toxic employees in the workplace. Can one bad apple really spoil the whole bunch? As it turns out, in the workplace, it can. Toxic employees can be the reason relatively good employees leave the company, slack on their work, and endure more stress and burnout. Interestingly enough, a study conducted by Cornerstone concluded: 1. Good employees are 54% more likely to quit when they work with a toxic employee. If the proportion to toxic employees on their team grows by as little as 1 in a team of 20. 2. As toxic employees make their coworkers significantly more likely to leave, replacement costs rise greatly. Hiring a single toxic employee into a team of 20 workers costs approximately $12,800, whereas hiring a non-toxic employee costs an employer an average of $4,000. Toxic employees can create a huge mess within the workplace, not to mention take a toll on the company's overall well-being in more ways than one. This is why it is important to understand how to spot a toxic employee and mitigate the effects of their toxicity before it gets worse. To spot a toxic employee, you must be able to gauge the following. 1. The likelihood of a team member being dismissed for toxic behavior. 2. The likelihood of a team member leaving voluntarily. And 3. The workplace performance of team members. Based on these three figures, 3 to 5% of all of your employees will meet the criteria for being termed as toxic. Now begins the difficult but necessary task of filtering out the bad apples so the good ones can thrive. To begin, you must factor in employee performance to segregate the toxic employees from the non-toxic employees. To do this, calculate these measures of employee performance. Number 1. Customer Satisfaction, or CSAT. This score indicates how satisfied customers are with the service they receive. Number 2. Average Transaction Time, or ATT. This is the average time an employee spends on a given customer transaction. These two performance indicators are used to understand how the relationship between the quality and quantity of an employee's work was impacted by the presence of toxic coworkers. Employees who are self-proclaimed rule followers, as well as those who struggle to show up to work on time, have a low level of reliability, and are not inclined to help others, are often markers of a toxic employee. Employees can set benchmarks according to specific company-wide standards and expectations. Employees that consistently fail to meet such criteria can be considered toxic employees who impact the workplace. To that end, it is critical to focus attention on avoiding toxic employees and eradicate such behavior before it spreads.
Based on the video just now, employees with problems are usually will be taken into disciplinary action. Talking about disciplinary actions, there are two disciplinary actions in the workplace, which are positive discipline and the other one is progressive discipline. A positive discipline is based on the philosophy that violations are actions that usually can be corrected constructively without any penalty. On another note, a progressive discipline incorporates steps that become progressively more severe and designed to change the employee's inappropriate behavior. The sequence for this particular action usually starts off with a verbal and a written reprimands in the form of suspension before resorting to a dismissal. However, there are a minority of managers or supervisors who are reluctant in executing disciplinary action against the problematic employees. One of the reasons why they do not take this seriously of this method is because of the fear of lawsuits in addition to the lack of support by the higher management. Moreover, there is a certain organization that has this cultural thing set in which disciplinary actions are always avoided, just like bribery, that seems to be a normal kind of gift in their organizational culture. The fear of losing a friendship and avoidance of time loss also contributes to the fact that this management is reluctant to apply disciplinary action to their employees. Or to sum up, the most of them have a conflict of interest whenever this issue of a problematic employee happen to be in their company. But let's say the 50% or more possibility that these problem employees are taken for disciplinary action. It is part and parcel of the workplace responsibility that the managers or supervisors to document everything that happened. This process of documentation consists of documents that provide proof or evidence for something or a record that your organization keeps and uses to inform decisions within your company. In terms of the employee's problem, the documentation shall consist of performance and behavior expectation, the employee's specific failure to comply, prior warnings or counseling with the employee, expectation for future conduct, and also consequences for failure to correct deficiencies. These documents shall determine the whole process output for the progressive discipline taken upon to the said employee. I have been explaining the sequences for the progressive discipline, and now we came to the last part of it. As you can see, the process for termination can be simplified into three ways. The first is warnings that are given to the problematic employees either verbally or through warning letters. Next, if the bad behavior is kept on, the document report is given to a legal officer for review, and if it is approved, the employee will be dismissed from the organization. Once he or she is dismissed, he or she needs to sign a formal contract with the organization they are working with before. This contract is actually a separation agreement that clearly mentions that the employee will not sue the organization with exchange to the benefits given. Most of the time, the agreement is signed peacefully between both parties as long as both respected each other. An additional fun fact, in Malaysia does not have an at-will employment system. In summary, employers cannot just hire and fire at will. They can, however, terminate an employee's services if it is justified, done in good faith, and is procedurally fair. So let's say if you are an employee in a company, you are not problematic at all, but you got fired instead. Well, this is called as a wrongful termination. Unfair dismissal or a wrongful termination of an employee is an act where an employer terminates, dismisses, or removes an employee without providing any valid grounds of removal. It is imperative that the employer furnish strong and valid reasons for termination, and in case it is not provided, it is actually a wrongful termination. Wrongful also because the employee is not provided an opportunity to be heard. With this, even the fundamental legal principle which says, listen to the other side, stands violated. Wrongful termination examples include sexual harassment and/or a hostile work environment, race discrimination, retaliation over workers' compensation claims, violation of the Family and Medical Leave Act, wage and hour violation, and also whistleblower retaliation. Well, I would like to highlight here on the whistleblower retaliation. In this case, there are other reasons such as being fired for blowing the whistle on your employer as you report issues that are engaged to them, such as lack of safety in the workplace, or report some illegal activity in which your employer is involved. For example, if you reported sexual harassment in your workplace to the company's human resource department and you were soon fired after, that is a sign that your employer fired you as an retaliation for reporting the harassment. When this happens, as an employee, please acknowledge your labor rights and fight back either peacefully or by sending a lawsuit. An equal and fair environment workplace is vital as it is also part of our rights. All in all, that concludes the whole topic of workplace rights and responsibilities. It can be summarized that it is extremely important for us to be aware of our rights and responsibilities so that we can hold onto our ground when things seem to be shady or affect our principle of integrity. By completely understanding our rights and responsibilities, it ensures us to acknowledge that the best ethical and morality came when we knew what is right and what is wrong. In another similar perspective, it is essential that every employee understands his or her rights and responsibilities in the workplace. There are many laws that protect the safety, well-being, and rights of employees at work, and it is important that employees understand their rights and responsibilities relating to them. However, you do not need to know each law in detail. But let me remind back two terms that are extremely vital in this topic, which are rights and responsibility. First, rights. Rights are what are due to you according to the law, whereas responsibilities in law are actions that you must do. So, in your workplace, there will be procedures and policies based on these laws, and it is your responsibility to follow those procedures. I will now close the presentation with a quote by John D. Rockefeller. He said that every right implies a responsibility, every opportunity is an obligation, and every possession is a duty. With that, we thank you for lending your ears for this topic. Thank you.